Okay, hello comrades. I'm Matthew Hall. I'm joined today by my colleague Paul Lakin, and the title of our talk today is Hopeless Claims under the 1975 Act. I'm going to start things off by just a trip down memory lane. A certain well-known, popular Manchester Section 9 judge once made an award under the 75 Act with this as his reasoning. And it's difficult, by the way, for me to read this out without falling into an impression of the judge, but I'll have a go. I must find an appropriate sum of capital which should be awarded to Monica, and doing the best that I can, and how much is always one of the most difficult questions a judge ever has to answer or a barrister has to advise upon. Counsel will know that very often within a set of barristers' chambers, people will go into each other's rooms and say, "We have a claim under the Inheritance Act. These are the facts. How much?" And you will get from members of chambers differing answers over sometimes quite a broad spectrum. For better or worse, the case has ended up before me, and no doubt one party will say it is better for them, and another party will say it is worse for them. And perhaps they might both say it's worse for them. And if that is so, that would be a very good indication that I've got it about right. Now, the members of the Court of Appeal were rather critical of the lack of of judicial analysis there. And the cases Fielden and Cunliffe. But 3 years after the only Supreme Court case on this matter, Ilet and Mitson, it's tempting to think, in my view, that no amount of analysis will ever give rise to any more certainty. Whilst the title of today's talk is Hopeless Cases, and I'll just share the screen now, it has to be recognised that since Ilet, a lot of cases are rather less hopeless than they might otherwise have been. Just starting then with Ilet, I'm not going to go into much detail about it, but here they are. Here's Heather and Nick Ilet. And there are two principal issues with this, which I think just need to start us off. The first is the question of maintenance, the first problem. And Paul is going to deal in a moment with that in the context of the recent cases on CFA uplifts. The second, though, is the fundamental question of what it is that makes lack of financial provision unreasonable. And I've mentioned there the case of Coventry. Now, if what the Supreme Court said in Ilet was that re Coventry is correct. And that was the case which decided that it wasn't enough just to point to a relationship of parent and child and poverty and a large estate to get an award under the Act. But standing back from Ilet, if that isn't enough, what was it about Heather Ilet that got her any award at all? It seems to me that really all she had was her relationship with her mother and her poverty. This is the letter, a copy of the letter from the evidence in Millet. I'm not sure it's very visible, but it's the letter that Melita Jackson, Heather Ilet's mother, the deceased in that case, wrote explaining the reasons why she had excluded the claimant, Heather Ilet, from her will. Thanks, by the way, to Stephen Lawson for providing me with a copy of that. What it says is, "My daughter left me on Sunday, the 18th of February 1978, when she was only 17 years of age. Whilst I was still sleeping, she crept out of my house in the early hours of the morning." Now, you can hear in that letter the heartache and the high feelings that thing so many years before had caused. Well, Heather's mother, Melita Jackson, who wrote that letter, was found by the trial judge to have been capricious and harsh. And that's another problem, because if we're going to take into account the relationship between the claimant and the deceased in deciding what's reasonable and unreasonable. And indeed, the Supreme Court in Ilet said that we should. Lord Lloyd said it would be of considerable importance to look at the relationship. Many claimants may point out that whilst Heather Ilet had a very bad relationship with her mother, she was estranged, that they had a good relationship with their parents and had nevertheless been left out, so that it's even more unjust for them to get no award. In my view, it would be wrong to categorise any of these hopeless claims that we're talking about as being in any way frivolous. As the letter by Melita Jackson and the Daily Mail headline, "All I Wanted Was My Mother's Love," reveal, what motivates people in these claims is not really maintenance quite often, but the things that arguably motivate us all the most: love, status, entitlement, memory, and of course, money. Now, it was widely remarked at the time that Ilet would set the stage for a proliferation of claims, and so apparently it has proved. So I'm going to hand over now to Paul to deal with the widening concept of maintenance, which I just mentioned earlier as one of the problems with Ilet, and how that's given rise to problems in two recent cases concerning CFAs. Okay, Paul. Paul, you're on mute. Hi, Paul, you're on.
I'm back again now. Sorry about that.
There you are. Right.
We'll start again.
We do want to hear from you.
Yeah, right. Let me start again. One of the things it was hoped that the Supreme Court would deal with was a concept that's central to the 75 Act, which is the notion of maintenance. Maintenance, of course, is the standard of provision that's applicable to, in most cases, other than spouses. Up until Ilet, the courts had by and large avoided any great judicial pronouncement as to what really maintenance was. So the matter came before, as I say, the Supreme Court, and it was hoped that this would really set the limits as to how it was supposed to be looked at and what did and didn't count as maintenance. In the end, on this issue, the Supreme Court, to say they bottled it is probably been kind. The decision was very much like most county court judgments that you would see at the time, in that they affirmed that the decision in Reed Dennis was correct, and the whole of the Supreme Court agreed that what was said in that case was how maintenance should be viewed. And again, it's worth looking at, and on the slide there you will see in full the quote, because it's worth reading closely, because it's become one of those quotes that's used so widely that people forget what it actually says. So it says, "In my judgment, the word maintenance connotes only payments which directly or indirectly enable the applicant in the future to discharge the cost of his daily living at whatever standard of living is appropriate to him. The provision that is to be made is to meet recurring expenses, being expenses of living of an income nature. This does not mean that the provision needs to be by way of income payments. The provision can be by way of lump sum, for example, to buy a house in which the applicant can be housed, thereby relieving him pro tanto of income expenditure. Nor am I suggesting that there may be cases in which payment of existing debts may not be appropriate as a maintenance payment, for example, to pay debts of an applicant in order to enable him to carry on a profit-making business or profession may well be for his maintenance." So there's a lot packed in there, but essentially what it's saying is the expenses have to be of a recurring nature and of a day-to-day kind of expense that you would meet on a monthly or weekly basis, such as bills, rates, water, all the usual kind of things. And clearly then rent and the provision of housing is one of those matters. Now, certainly when I started in the bar 20 odd years ago, the payment, it was accepted wisdom that the payment of debts was not part of maintenance, and it was based on that last part of what was said in Reed Dennis, because what's said in that quote is that the payments of debts can be, but as long as it enables a business or some other means of successfully making income to continue. So payment of debt for debt's sake alone was not seen as part of maintenance. And as we'll see, that, like so much as what is maintenance, seems to have moved on. This is what the Supreme Court then said in Ilet about maintenance, which is that the level of maintenance may be provided is flexible. So again, there's nothing new about that. And again, it can be capital as well as income. And of course, immediately, this is where some of the tensions arise, in that the whole concept of maintenance is a periodic payment, but of course it can be provided for by payment of capital. And so there is an immediate tension between the two. What the Supreme Court did say, and was probably the only slightly ring fencing of things that they did say, is that it was always thought perfectly reasonable that a claimant could be provided with a house, because obviously housing needs are one of the basic human requirements, and that the payment of capital to purchase a property was proper maintenance, because that freed up rent and other payments that could then be also used for maintenance. But what the Supreme Court said is that's better provided for by way of a life interest rather than an outright payment of capital. So even when looking at the provision of a capital sum, it's still better done by way of a life interest rather than outright payment. That brings me on to the recent case of Bullock and Denton, which came before His Honour Judge Gosnell of Leeds. The decision is actually dated the 15th of April this year. It's unreported. But the facts of the case are basically that the claimant and the testator had an on-off relationship for about 3 and a bit years. The testator died, leaving an estate of over £2 million, and that was all left to the testator's brother. The claimant at the time of the trial was 61, had limited income as a carer and large debts. She also, there was evidence that she had been provided with housing by the testator during their relationship, but that was disputed, but the judge found that that had actually been made. So what did the judge do? What he did was provide £140,000 to be provided out of the estate to purchase a property which would revert to the estate upon death. Again, I don't think really any criticism can be made of that part of the decision, and that's in keeping with what the Supreme Court said in Ilet. He went on then to make a lump sum of £24,000 so that she could service her debts. Now that was basically capitalised up on an income basis, a lump sum just solely for the purpose of payment of her debts as a separate head. Again, it's questionable really, and even the judge recognised that that was arguable as to whether or not this amounted to maintenance at all. But then he also granted a lump sum of a further £5,000 to replace white goods that were apparently in need of replacing, and that feeds directly from Ilet, where of course what the Supreme Court said in that is that Mrs. Ilet should use the £50,000 that she had been awarded and she should spend it as quickly as possible so that it didn't affect her benefits, and purchase a whole array of white goods that were needed. And apparently the Supreme Court didn't see that as a problem or in any way a conflict with the definition that they had just given. To my mind, the replacement of white goods, the purchase of anything, is wholly against the concept of maintenance as they defined it earlier in their judgment. It raises all sorts of questions. It's like, well, how often are you supposed to replace white goods? What class of white goods are supposed to be the essential ones? Are microwaves essential? Are fridges? Are fridge freezers? And so on. And then how long are you supposed to keep them before they are replaced? And what happened to the good old-fashioned notion of getting things repaired? I don't know. But anyway, this seems to be the way things are going, in that white goods are now okay. But also on a more conceptual level, it makes you question that if the purchase of chattels can now be classed as maintenance, then conceptually it doesn't stop the court awarding, in whatever circumstances, somebody asking for anything, quite frankly. But perhaps the most controversial aspect was that he awarded a further £25,000 to defray, this is what the words he used, the additional costs of a solicitor and counsel under a CFA uplift, which was set at 50%. This is way after the Jackson reforms, so it was conceded by all sides that the uplift could not be awarded and recouped against the defendants, even when as they had been successful. And you'll see on the slide there the reasoning that the judge gave for making the award. He basically said, in my view, I'm entitled to take it into account because they fall within the claimant's financial needs under section 1A. But the interesting thing to note, when the judge did his analysis of the claimant's financial needs under 1A, there was no mention of this potential liability at all. So it seems to have sprung up after that assessment had taken place anyway. And then he says it's the date of trial, not date of death. He made the point that there was no authority on the point, and to that case he was actually wrong. There was, and I'll deal with that in a second. But the real thrust of it was that he'd made a fairly basic award as he saw it, and that if he didn't make this lump sum, then it would be a sum that she would have to pay, and it would eat into what he had awarded. Effectively, it's the same argument as used to be run in the benefits case, that if you awarded a large sum, or a sum of a certain amount, the actual impact in the real world would be that the claimant would be no better off, or potentially could be worse off, depending on how all the benefits worked out. But he didn't conceptually have any problem with it and awarded 25,000, even though at that stage he didn't know what the actual costs were, what the uplift really would be. And the slightly bizarre thing was that the claimant had been to earlier solicitors who had entered into a damages assessed CFA, but he said there were issues with the enforcement of that first agreement, so he didn't take it into account, which beggars the question, given that this is all before the issue of costs has been sorted out, to what extent and to how much does the court have to take into account issues of enforceability, issues of what is the correct level of uplift, such matters as questions of refusal to mediate and Part 36, all of this which will have an impact upon whether or not there's actually any level of success and the knock-on consequences that that can have for costs. But fundamentally, and I think even as at a conceptual level, I have real difficulty with seeing a payment of a sum that you have entered into simply as a means of funding litigation that can be seen as by its definition, as maintenance as defined under the 1975 Act. I have really real difficulty with that as a concept. However, His Honour Judge Gosnell is not the only one. It came before, in the case of SH and NH, before Mr. Justice Cohen, which is even later. I think this is a decision dated June of this year, maybe May or June. And the same issue arose. I think the question was on this one it was slightly even more oblique, which was because it was about Part 36. But he was referred at least to the decision in Re Clark, which is the decision of the Deputy Master Lindwood in the Chancery Division, where he declined to increase an award to include a success fee on 5 grounds. Firstly, that the calculation of damages is a matter of procedure carried out before costs are considered and has never included an element of costs. To allow it would be contrary to legislative policy that the losing party should not be responsible for a success fee. It would amount to an increase in damages by way of costs, and it puts the CFA-funded litigants in a better position in terms of negotiation due to the risk of substantial costs burdens, and it would put the claimant in an Inheritance Act proceedings in a better position than, say, a claimant in personal injuries. Basically, what the Deputy Master's position was, this would drive a coach and horses through the notion that uplifts are no longer recoverable as a matter of policy, because what you're doing is just simply taking them out of the estate. But given that 75 Act claims are in reality claims between the beneficiaries, the effect is exactly the same. Whether it comes out of the estate or it comes directly from the defendant, it's still the defendant who's losing out. But in that case, Mr. Justice Cohen still decided that it was appropriate to make an award of costs or to increase the award in the circumstances to take account of the uplift. And that's where he says, I accept that it's appropriate for me to consider this as a liability as part of C's needs. And I do so rather for a case-specific reasons. But again, this, to my mind, shows where it goes wrong. Yes, you could take it into account in terms of the factors under Section 3(1)A, I think it is. But that feeds into the overall question that you have to ask is whether or not the will makes reasonable provision. And then if not, what is proper allowance? It should not be dealt with, because this is to some extent the Supreme Court's criticism of what the Court of Appeal tried to do in Ilet, is have a notional amount that you say is the correct, and then it increases or decreases according to relevant factors. So I think as a matter of policy, it is wrong. And as a matter of law, in my view, it isn't correct. But it is and does appear to show a direction of travel that the courts are prepared to make, which, because of the facts of Ilet, shows a general widening up of the whole concept of maintenance. So where does that leave us? The concept of maintenance appears to be spreading. It is no longer simply, I think Matt and I were discussing the days of putting schedules together of payments in and payments out so you could argue about each amount. Those kind of limitations seems to have gone. Now it's, well, I need all sorts of things. And I don't really see there being a problem with saying I need Sky or better broadband or whatever it is now, because there's no difference between those kind of electronic items and white goods. So in terms of what you can claim, the rabbit seems to be well and truly out of the hutch. Because it covers, as I see there at 2, white goods. Why not any chattel of any kind? Cars, vans, whatever. It appears to cover holidays, again, because it seems to be just an entirely notion of what it is. And that comes directly from Brenda Hale in Ilet. And now it also covers the payment of liabilities that you've agreed to undertake in order to pursue the litigation. So if Ilet itself wasn't enough to drive forward litigation in this area, then these kind of decisions certainly will, because the lawyers will see it, and that depending on whether you're on one side or the other, you'll see it as a good thing or a bad thing. You can actually act on a CFA, still act on an old style CFA with an uplift, and there's no question of the uplift being challenged at the point that the order is made in court, because it's before any consequences are considered, in the way that normally you'd have to establish that the uplift was reasonable, that the CFA was legal and all the rest of it. But of course, because the cart is before the horse, that can't happen in these cases. So again, the position is not very clear, I'm afraid, is the best that we can really say, other than it appears to be expanding rapidly, in which case I will hand back over to Matt to finish off.
Yeah, thanks, Paul. I mean, we may see people with speculative cases being further emboldened, I suppose, by the potential for them to recover even their uplift through an award from the other side. I'm going to revert back to the theme of hopeless cases, though, if I may. So the recent case it's not a reported case, but it has been prompted quite a lot of comment online. And in particular, the hero of the case really is a chap called Alan Johnson, who was a retired solicitor. And he decided to represent the unfortunate defendant who was facing a claim which the deputy master ultimately described as absolutely hopeless. And he acted as a Mackenzie friend when the defendant wouldn't otherwise have had access to any representation. He's written an excellent article in the Law Society Gazette, and there are some comments on there about the proliferation, on the comments board, about the proliferation of hopeless claims and some discussion about what to do about them. Just dealing with that then, what sort of claim can be described as absolutely hopeless? It might be illuminating just to have a look at. The defendant was a widow. She had motor neurone disease. The estate, by the way, she was the testator's widow. The estate wasn't very big. Most of it was tied up in her house. Her house had been modified so as to take care of her disabilities. Claimant, by contrast, wasn't anybody who needed money particularly. She was comfortably off with her husband. And it appeared through, as the judge said, during the course of the hearing, that she was motivated by a view that she would be entitled simply to a 1/4 share, there being 4 children. The master said that he would have awarded indemnity costs in the case. So there's no doubt that claimants are being emboldened, particularly excluded adult children. And the question there, I suppose, is, well, what are your options? What are your options if you're facing such a claim? Now, the first thing I think that you need to get to the bottom of is, well, how hopeless is the claim? Because don't forget that there are 2 central questions under the Act. And I think that these are often actually overlooked by people making claims. Firstly, and I think they can be summarised in these 2 questions. Firstly, the financial provision which it is reasonable for me to receive for my maintenance is. That's the first question that any claimant has to answer, in my view. And secondly, the lack of that provision is unreasonable or produces an unreasonable result. That's the language of Coventry. Because, and unless those 2 questions can be answered, then it doesn't seem to me that there can be a claim. Now, what happens in reality is that the letter before claim quite often will list all of the factors under section 3. It'll go on and on and on about, those and how somebody hasn't got very much money. But they fail to address what order it is that the claimant will actually seek at trial. Now that's, as I say, quite common. In fact, I was looking at the ACTAP's pre-action protocol, and even the letter that's suggested as a pre-action letter by that the Association of Contentious Trusts and Probate Specialists doesn't actually have any box to set out what order is it that I want. Now, ultimately, that question will have to be answered. I could not stand before a judge as counsel opening a trial without telling the judge what order I am seeking and why. So if that ultimately has to be spelt out, it can be spelt out at the beginning as well. And there's no reason, it seems to me, when facing a claim that you shouldn't ask the claimant or the potential claimant simply to answer those two questions with supporting reasons by reference to section 3. I just mentioned one other case, if only just to dismiss it out of hand. This is the Wellesley and Earl Cowley matter. Back to the Daily Mail. Cash-strapped Earl's daughter, 56, was estranged from testator for more than 30 years, sues for slice of £1.3 million. So I think that's a decent as head note as any. But the reason why I mention this is that actually it was even submitted in that case that a reasonable starting point will be 10 to 13% of the £1.3 million. Why? Because in Ilet, that's what Heather Ilet got. She got about £50,000 out of the 486 or thereabouts that was in the estate. Now, the remarkable thing, it seems to me, is that how that notion that you could simply quantify a claim by reference simply to a percentage could even be entertained at all. Of course, it was dismissed out of hand by the judge in that case. But it does highlight, in my view, the prevalence of a lack of understanding and a lack of focus in these claims about why it is that it's unreasonable for provision not to be made and the amount of the provision that's needed for maintenance. So if you're faced with what looks like a hopeless claim, well, what about summary judgment? Now, if you think about it, looking at the facts of the Sevier case, Sevier that I just mentioned earlier on, which was described as a hopeless case, if you've got somebody who quite clearly does not need to be maintained because they're comfortably off, or who puts forward a case based on quite patently a mistaken understanding of what maintenance is, the way is open, it seems to me, to make an application for summary judgment. There's only one reported case that I could find considering that, and it's the case of Mr. Justice Mostyn's decision in Delal and Delal. What would you need to consider? Well, I think, as with any summary judgment application, really it's only worth making that application if the saving in costs and time that will be occasioned to you if you win are worth the risk of having to pay the costs if you lose. So you may have some cases where there's probably not that much in terms of disclosure or further evidence that you'll need anyway by the time you reach trial. In those, you're probably better off just waiting and getting on into court anyway. However, you might have cases where there are hundreds of little factual issues that all need to be unpicked before the judge could make a decision, and it looks like it's going to be a nightmare. If it does look really hopeless, there's no reason in principle why you can't have a go. The test, of course, is not like a strikeout where you have to show that somebody's got a legally hopeless case. The test, of course, is just whether a claim is realistic or, by contrast, fanciful. And some of the cases that we see, indeed, probably are fanciful. Overall, though, it's probably unrealistic in this arena. Now that we're into claims being made for little things, as Paul's just mentioned, the white goods, the holiday, all of those were countenanced in Ilet itself expressly in the judgments of Lord Lloyd and Baroness Hale as the sort of things which might amount to maintenance. So it's not going to be any use if you get in front of a judge on a summary judgment application and then the applicant says, oh, well, yeah, I might not have much of a case on overall maintenance, but then again, I do need a new wardrobe, a new second-hand car, and so on. Make me a modest award. What about early neutral evaluation? Is that an option? Well, the case on this is decided in August last year, is the Court of Appeal Authority in Lomax and Lomax. I've said early neutral evaluation stroke FDR. FDR, for those who don't have any dealings in on the family jurisdiction, that's a financial dispute resolution hearing. And it has essentially, as the judgment of Moylan, Lord Justice Moylan makes clear in Lomax, it has effect. It takes effect in pretty much exactly the same way as an early neutral evaluation anyway. And they are, in fact, FDR hearings are now routinely, in my experience, ordered to take place in 1975 Act claims. What happens is that you'll go in front of the judge for your normally the first directions hearing, and in advance of giving the directions, if you don't settle a case, the judge will give some indications about how he or she sees the lie of the land. Now, in my experience, these hearings are really, really good. In fact, the biggest case that I ever had to do, which was a £5 million or thereabouts estate, was eventually cracked by His Honour Judge Bird, making some very trenchant observations about the applicant's case at one of these hearings. So the advantage is obviously that it's not like a mediation, because the mediator is a judge. And if you get a good judge, or what I think would be a good judge in these circumstances, they will be trenchant, like His Honour Judge Bird was in my one. Now, one thing, just coming back to my point about these two fundamental questions under the Act, i.e. reasonable financial provision for me is, and it's unreasonable for me not to have that, because if you have one of these hearings coming up, ask for a direction that the claimant sets out her answer to those two questions by reference to Section 3 as a position statement for that hearing. In fact, I've seen orders, notably made by District Judge Khan, as he then was, ordering a claimant in a 75 Act application to do precisely that. Just brings me on to evidence, because normally when a claim's issued, you will only have the evidence that's put in support of the claim under CPR Rule 8.5. Strictly speaking, that all of the evidence in support of the claim has to be served with the claim form. That's what Rule 8.5 says. You only get your second bite at the cherry in reply. That's what the rule says. So what you could argue, I suppose, is that insofar as there is no initial evidence about what is reasonable provision, then the claim's defected from the word go. But the answer is, it doesn't work like that. In reality and in practice, there are quite often successive waves of evidence in these cases where the claimant can patch up holes in his or her case as they go along. So where does that leave us then? Well, to conclude, you can have a go at summary judgment. There's nothing to stop you. It's unlikely, I think, in the light of Ilet and the cases after Ilet, one of which the Re-H case that Paul has mentioned, that it's going to be a very good idea unless it's really obvious that the claimant can have absolutely no need of anything from the estate. That Sevier case could well have been an application for summary judgment material. It's probable that they didn't bother in that case because there's nothing to be gained anyway, because once you're into trial, it's all the evidence is there anyway, and it might not have been that much by way of a saving. Really, I suppose, to conclude, think about that. Think about getting the other side to answer those two fundamental questions that I've posed. And I suppose then that if all else fails, you could always give one of us a ring in chambers, and we'll wander up the corridor like His Honour Judge Howarth said that we would, and ask around and see if anybody's got any ideas about what the quantum should be. But no, there is no overall answer to hopeless cases unless they're completely hopeless. And that's all really I have to say on that. So I think we're just about on time. Paul, do you have anything else you want to add? You need to unmute yourself again.
Yeah, the only thing I'd add is it's all too common, and this is one of the fundamental problems of Part 8 that I have a real difficulty with, to get to trial and for the parties often not to have really thought about what it is that they're actually fighting about in any specifics. And if you read Ilet itself, it makes clear that when it was heard at first instance before the district judge, the only time that numbers were put forward by the claimant was in final submissions, and then when the judge really had to press for what the claimant was actually claiming for. And that is just an all too common event as to people not thinking and not planning about what it is we're actually claiming and how this is going to be. As it happens, once they were required to quantify it in closing submissions in Ilet, what they actually claimed, because of the various amounts and how they said it should be all capitalized, was actually greater than the amount that was in the estate in total. So it just shows the danger of doing it. So immediately that is not going to impress any judge if you prepare a case on that basis, because they're just going to think, well, you're just making wholly unrealistic requests or demands, and there's no way that they're going to make an award in those kind of figures.
Also, so if you read that article by Alan Johnson, who was the Mackenzie friend in the Sevier case, who very kindly helped the poor defendant there, he revealed in the article that what was being intimated by way of the claim initially was £237,000. But by the time that the case came to be opened at trial, that had gone down to 75,000. I mean, I think one of the only things and the most effective thing that you can try and do is just to seek to pin down the answer to those two questions, which I've referred to in my slide. If anyone wants to put a question up, I didn't mention at the outset that you're quite welcome to put something on the chat or just email us. I think we're going to get thrown off in a minute.
Yeah, we've got time. We need to.
The webinar facility is needed for the next one. Oh, hang on, we've got one here. I found seeking a provision order sort at case management stage has been effective. Yeah. Oh, thanks, Jenny. That's a good point. As I say, I think at any stage, if you ask the judge to make an order for the claimant to set out what they want, I think that will normally be granted. Okay, I don't think there's anything else then. Thanks, Jennifer, for that. And okay, unless you've got anything else, Paul?
No, I think that's it, thanks.
Anyone email us, and as I say, we'll walk up and down the corridor, probably the virtual corridor, and ask our colleagues what they think. Okay, I'm going to press stop now.
Thank you.